Hi, everybody. We are in the last week of the course. The last time you're going to have to listen to me, and last time I'm going to have to do one of these. So here's just a quick review of the major points. You've got people that are going to go into law enforcement. This class is really important so that you have an understanding of what happens to your case once you file it. How does it proceed through the lower court, the trial court, and then upon appeal, where does it go? And what happens later if there's a post-conviction collateral attack. Those of you going to law school, absurdly important course. This will set you up so that you have an understanding, a basic understanding of how the court system works when you're in law school. Researchers, those of you that are going to go to graduate school, master's degree, PhD potentially, the benefit of this, if you stay in this genre, in this field, you're going to need to know the court system because you're going to run into cases all the time, and part of your research will be based on this. Those of you that are going and are going to go on and maybe go get a job, maybe get out of this field because you found you don't like it, this course is really important for 340 and 350, criminal law and criminal procedure. Here's the things I want you to get out of the first part for sure. First off, court structure. How are the courts set up? From the trial courts all the way through the state court of last resort, the trial courts on the federal side, the federal court of last resort. How do cases get from the state court of last resort to the federal court and the federal court of appeals? How do they get to the U.S. Supreme Court? Really tricky there because you're going to be dealing with both habeas corpus to get into the federal appellate courts, and you're going to be dealing with the U.S. Supreme Court, initially dealing with constitutional issues. Second thing, part of that constitutional issue, jurisdiction. What courts hear what cases? Extremely important for the three groups I talked about, but really important for those law school bound people. Pay real attention to that. Where do we get controversy in the court system? Well, even there's controversy in jurisdiction, in the court structure, how things are dealt with. From the arrest, or beginning of the investigation, is probably a better way to put it, from the field, the way I have my notes, to the courtroom, that's where real controversy occurs. And that occurs by, was the law enforced actually violated? Was that law constitutionally written and written by the legislature? If you pass that part, then you've gotten through the procedural aspects of the rule of law. Now we move down to the enforcement, were the actions of the police, the prosecutors, the government lawful? Did they comply with the Constitution? Did they enforce the law with established procedure? Now, that's the enforcement part of the rule of law. The next thing is the players in the courtroom and this idea of the courtroom work group working together to keep the courts running so they don't just bog down. And that's through the plea bargain and throwing out cases and deciding what to file, what cases may be important for policy reasons, and what cases aren't important for policy reasons. You've got the judge, the prosecutor, really important part of this because they make the decisions on filing, and they're usually really involved in the plea bargain process. Defense counsel, those are the three main players. And then you have probation is in there with the pre-sentence investigative report for adults, very involved in the juvenile side, but for adults on there, and not so much in the adult court. And then all the other players, the courtroom security, the clerks, the staff that actually do the business of the court, the witnesses, defendants, and victims. All very important parts of this. The next thing is your court process. I want you to be really up to speed on that court process and how that works from arraignment all the way through sentencing. What we're going to talk about today is is post-conviction relief. So what happens when a person is convicted? Well, if their attorney made a timely objection, that can be raised in appeal. The police do a search which defense counsel believes to be unlawful. However, the defense counsel does not file a motion to suppress. There is no timely objection, so that issue is lost. If defense tries to file an appeal, it will show up in the record that it wasn't objected to, and the appeal will be dismissed and won't be heard by the justices. Now, who can appeal? Only the defendant can initially appeal. Of course, it's the law, so there's going to be an except over here. Somewhere at the end of that statement is an except. Let's talk about the general rule. General rule is you can only appeal if you're the defendant. And the reason? Double jeopardy. The prosecution loses, they appeal, judge says, you're right, you can retry them. Well, that violates double jeopardy. Now let's get to the except. The except portion of it is, unless there is an important question of law, the defendant isn't in jeopardy, but the prosecution may want to appeal to get this important question of law ruled on. Now, a silly case. Orange County traffic officer stops some guy for tinted windows, writes him a citation. Guy pleads not guilty. He goes to trial. He says, hey, Your Honor, I got Arizona plates. Arizona, you can have tinted windows. I do business in California. I do business in Arizona. I'm driving on business in California and I get this citation. That violates the Commerce Clause of the Constitution, which says that the states cannot interfere with interstate commerce. The judge turns to the officer and says, how do you respond? And the officer says, and that's probably a bit more eloquent than what the officer said. So, found not guilty. Well, the problem is then that's the law. The Commerce Clause in that area in Orange County, the Commerce Clause precludes citations for tinted windows. Now, there's a constitutional argument that overcomes that, but it has to be done through an appellate court. So the prosecution files an appeal on the important question of law on the Commerce Clause. They take that to what's known as the Appellate Division of the Superior Court. And that's judges when the Superior Court will hear appeals for infractions and misdemeanors. They review the case and they say, nope, this is an important question of law. It needs to go to the 4th District Court of Appeals. And the prosecution, the state makes the proper arguments to overcome the Commerce Clause issue. But that's how you appeal something on if you're the state. The reason for the purpose of appellate law is error correction and policy formation. So if the the trial court makes an error, and that error is so significant that it should reverse the opinion or reverse the outcome, then that will be heard or is the purpose of the appellate court. Policy formation is a little bit different, and that's where the courts want to impact how law enforcement's done, how the court system is handled. And let's go back to the traffic citation. The policy issue is whether or not you're going to allow the Commerce Clause to affect, it's a tenuous argument, it's going to affect traffic enforcement. That's a policy reason, or policy formation issue. Appeals are discretionary, meaning that most courts do not have to hear an appeal. The only exception is the Supreme Court, the state Supreme Court, in a death penalty case, and the U.S. Supreme Court in a death penalty case on the federal side. They must hear an appeal before the sentence can be carried out. Even if the defendant doesn't appeal, there has to be briefing and argument in front of the state Supreme Court on the issues. Was there error, to make sure there was, or try to obtain it or determine whether or not there was error, or is there a policy issue that we're trying to work on here. Process. First off, defendant files a notice of appeal. And that has to be done within 10 days after a conviction. Once that's filed, then the record is gathered. And you know the person that does this and the typewriter in front of the court reporter, that's part of the record. Evidence is part of the record. Those are videos that are there. Those things, parts of the record, are then processed, put in a package, and sent to the appropriate court of appeals that will hear the appeal. Within 30 days, the appealing party, initially it's going to be defense, they will be, the defendant must, now the plaintiff will then file an appeal with, will file a brief with the appropriate court. And the brief is a document that talks about the facts, and it's going to be the facts from their side, from what they perceive. And it's not an objective presentation of the facts, but it's important. The next thing that happens is that will go to the court, and then also a copy will be served on the people, on the prosecution, who are now the respondents. They then read it, do their research, and they have so many days to file a response. They prepare their response, and then the plaintiff, the person that was convicted, their attorneys will file a response to the brief, and then there's a response to the brief, the next brief by the prosecution. All this goes to the appellate court. Appellate court reviews it. And then the next step is oral arguments. And what happens is the attorneys for both sides go to the appellate court, and they present a narrative of what they happened, what the law is, what they think happened, what the law is, and how it should be handled. And the appellate court judges will then ask questions. So usually, if you can go on to, I think, OYEZ, I think is the name of it, OYEZ, and even this U.S. Supreme Court website, and you can get recordings of oral arguments. It's pretty cool, because usually it starts out, Your Honor, my name is Greg Gibbs, and I'll be representing the plaintiff in this appeal. On this date and time, the plaintiff was driving down the street minding his own business, and then immediately the court, somebody starts to interrupt. and will ask questions about what's going on, what really happened, and all that. It's actually kind of entertaining to listen to. You actually really might listen to one or two if you are going to go to law school. Once oral arguments occur, justices get together, they discuss the case, and they vote and come up with an outcome, and then they appoint someone to write the opinion. And this would be the opinion of the court. This is what's published in the case books. What's published in, in these case books back here. These are all case books from the early 19th century and 20th century. So those are the opinions written. Opinion has several important parts. The first part is procedural history. What happened? So-and-so gets arrested, goes to trial, loses. The appeal now is before us, meaning the court. Then comes facts. What happened? What got them there? Now, when you read the facts of a court case, of an appeal, be really leery, because often the courts will write facts that concur with their holding. A great case is a pursuit case out of the Midwest. Cops try to stop a guy, he flees, it goes on, and he ends up, they use a pit maneuver, pursuit intervention technique, he crashes and becomes paraplegic. He then sues the police, saying excessive force. The police, they say, no, we didn't do any of that. And the things that he's saying, we would know that those were violations of the Constitution and a technical thing, which is called qualified immunity, which you'll learn about in other classes. Now, the trial court agrees with the police, and the injured party then files an appeal. And it goes through the process of the state, ends up at the state Supreme Court. State Supreme Court says, well, yeah, and the appellate court produces a set of facts. The state Supreme Court takes those facts, and the facts basically say this guy's driving away, and the police run him into a tree deliberately, and says that they should be liable for the damages. Ends up at the U.S. Supreme Court level. Awesome case. And the majority opinion was written by Justice Scalia, and many of my peers did not like Justice Scalia in the least. And I think that's because he disagreed with the idea of the Constitution being something that changed and could be molded to fit into certain facts. But Scalia says, did anybody look at the video? There's video of the pursuit. Anybody look at the video? This guy's running through parking lots. People are diving into bushes trying to avoid him. He almost crashes a couple times, runs red lights. And finally the cops say, this guy's going to hurt somebody, so we've got to pit this guy. They pit him at a high speed, which is not recommended, and then have a bad outcome. But here you can see where the facts that the appellate court produced and the state Supreme Court relied on are different than the evidence. It's a really interesting case. So, the next part will be the opinion. And the opinion is written by one of the justices, and will be what the court holds, what the court finds. Goes through the law, applies the law to the facts, and then comes up with a conclusion. in a three-judge panel, the other concurring justice can write his own opinion. So you'll see the opinion, and then you'll see a concurring opinion, and then you may see a dissenting opinion. And important to read them all because there's some really good stuff. When you look at Terry versus Ohio, the dissenting opinion suggests the police should never be able to talk to somebody unless they have consent or probable cause to arrest. Really important standard, probable cause to arrest. The opinion, the majority opinion, came to reasonable belief criminal conduct's occurring, reasonable suspicion. Huge difference. Would super impact how the police operated, in that they would have to be able to arrest anybody that they talked to that didn't want to talk to them. Kind of cool. How do you find an opinion? Well, the case citation will tell you where to go. If you did some research and you looked for a case and you found a reference to it in the case citation, these days you could Google the case citation. You could Google the case name in the court, Terry versus Ohio, U.S. Supreme Court, and you would get that particular case. When you look at the opinion, it will say 348 U.S. 1. That means you go into the 348th volume of U.S. reports, which is the Supreme Court Reporter, first page, and there you'll find the opinion. Okay? The volume number, the reporter, the opinion, or the page number, and you should have that. The next thing I want to talk about really quickly, and I really want you to spend some time on this, very, very important. The PowerPoint that Cengage produced, really good on this, is the idea of habeas corpus. Habeas corpus is also known as collateral attack, and what it is the defendant, even though it's bring the body, well, I'll explain it to you. The defendant is challenging his unlawful confinement. Habeas corpus, bring the body, what that means is, okay, they have filed habeas papers with the trial court, and there's issues of fact we need to figure out. Bring the defendant to the judge. And then it goes through the process from there. There'll be briefs filed, and then will be evidentiary hearings, because the habeas is different than an appeal. Remember, in an appeal, you don't place evidence. You don't produce evidence. You don't come up with a new witness. You don't come up with the bullet. Let's see. Okay. Yeah, I have something that's really kind of a cool thing. I wish I had. In any event, you don't do that. An appeal is the briefs, oral argument, and then the opinion. Habeas, it can be evidentiary, and you can complain about things that were not part of the trial, unlike the appeal. So make sure you spend some time with that. I really want you to know that what habeas is. When you see something from a criminal case, and it isn't, state or the people versus a defendant, or it's not, state of California versus the defendant, or something of that nature. You don't see a government agency in the first part, and it's two names of two people. Well, the first name is the defendant. The second name is going to be the person that is holding them, the warden, the county sheriff, whatever that particular person is, or who that is, because they have to bring the body. Okay, end of the course. I hope you got some stuff out of it. I hope you enjoyed it, and that you enjoy your time here at Cal State Long Beach, bang out this degree, and then move on to whatever the next part of your life is.